The unlikely counsel. The heavy oak doors of the Franklin County Courthouse swung open at precisely 10 o'clock, admitting a shaft of cool morning light into the marble-floored foyer. Among the milling crowd of lawyers in tailored suits and clients clutching folders, one figure stood out like a misplaced pawn on a chessboard, a tall, lanky teenager. Ethan Parker's dark blazer hung loosely off his narrow shoulders, and his navy blue backpack sagged with what looked to be textbooks and a violin case. His clean Oxford shirt and slim tie were immaculate, but the clothes, borrowed from his father's closet, did little to disguise the teenage lankiness and perpetual awkwardness that marked him as someone more at home in high school hallways than legal hall chambers. Ethan hesitated at the threshold of courtroom 3B, swallowing against a lump in his throat. His palms were damp, and he glanced sideways at Ms. Jansen, the public defender who had taken an interest in him after reading one of his online articles about constitutional law. She offered him an encouraging nod. "You'll do fine, Ethan," she whispered. He took a breath and walked in, every echo of his shoes against the polished floor announcing his presence. Judge Montgomery, a portly man of 50 with a bristling mustache and eyes that seemed perpetually narrowed in suspicion, peered down from his bench with a mixture of curiosity and incredulity. He had been told a young intern might be assisting in the morning's proceedings, but he'd assumed intern meant a recent law graduate, or at worst a paralegal. He had not expected a teenager. "Ah," said Judge Montgomery, leaning forward. His voice resembled gravel rumbling down a drainpipe. "You must be the intern. Young man, do you at least know how to address the court?" Ethan flicked through the pages of his legal pad, though he'd memorized his opening lines the night before. He stood straighter, squared his shoulders. "Good morning, Your Honor. I am Ethan Parker, and I've been assisting Ms. Jansen with research and case preparation in State v. Reynolds." A murmur rippled through the courtroom. Prosecutor Dana Reynolds, a sharp, impeccably dressed woman in her 30s, arched an eyebrow. Defendants, bailiffs, and court reporters exchanged discreet glances. The idea of a teenager facing a judge in open court seemed absurd. Judge Montgomery cleared his throat. "Very well. Mr. Parker, we will begin with your client's motion to suppress evidence obtained during a roadside search. Ms. Jansen, proceed." Ethan felt Ms. Jansen's satisfaction as she passed the floor to him. He adjusted his tie, trying to steady his voice. "Thank you, Your Honor. The motion rests on the Fourth Amendment prohibition against unreasonable searches and seizures. On July 14th, my client, Mr. Samuel Reynolds, was stopped at approximately 8:15 p.m. on Route 12 for a malfunctioning taillight. The trooper proceeded to question him for over 20 minutes without articulable suspicion of any criminal activity. He quoted case precedents, Terry v. Ohio, Carroll v. United States, as if they were Sunday bedtime stories. His voice, initially tentative, gained strength. He pointed to the photograph of the trooper's dash-cam footage displayed on the courtroom's screen. The patrol car's headlights reflecting off Reynolds's sedan. He highlighted the absence of Miranda warnings before the trooper asked the defendant to step out of the vehicle. Each citation of Supreme Court rulings carried weight, and even Judge Montgomery seemed compelled to listen. The prosecutor shot Ethan a challenging look. When her turn came, she rose smoothly. "Your Honor, the taillight violation provided probable cause for the stop. During the questioning, the trooper observed Mr. Reynolds acting nervously. She cited Wren v. United States, insisted that the trooper was within his rights, and concluded with her recommendation to deny the motion." Ethan stiffened deliberately before rising again. Some hairs had begun to stand on his arms. He articulated a sharp reply. Yes, the stop was valid. But once the reason for the stop was addressed, the taillight replaced with a new bulb, continuing the detention became unlawful. He methodically deconstructed the prosecutor's arguments, quoting Rodriguez v. United States, and pressing that the trooper's questions about drug use exceeded the permissible scope of a traffic stop. Judge Montgomery tapped his gavel lightly against the sound block. "Counselors, I have heard sufficient argument. I will take the motion under advisement and issue a written ruling." He glanced up at Ethan. "Mr. Parker, you presented your argument with remarkable clarity. May I ask how long you have been practicing law?" The entire courtroom held its breath. Ethan swallowed again, a flush creeping up his neck. Your Honor, I'm still in high school. I turn 17 next month. Even the judge looked momentarily taken aback. Ms. Jansen couldn't suppress a proud smile. Prosecutor Reynolds stiffened, her jaw clenched. The bailiff looked at Ethan as though he were an apparition. The gallery erupted into whispered astonishment. 17. Judge Montgomery repeated, eyebrows arched. And you're arguing Fourth Amendment jurisprudence as if you'd slept inside the Constitution itself. He leaned back, steepling his fingers. Well, Mr. Parker. Ms. Jansen, remind me again of your credentials. With a nod, Ms. Jansen stood. Your Honor, I am an advocate licensed in this state since 2009. Mr. Parker has been working under my supervision on a volunteer basis, primarily legal research. His extraordinary aptitude led me to bring him here today. Judge Montgomery's mustache twitched. He peered at Ethan's backpack. What's in the violin case? Ethan blinked. My violin. I play in our school ensemble. Of course. The judge's tone was half amused, half contemptuous. Well, Mr. Parker, I anticipate your motion to suppress will be well reasoned. Thank you for your assistance. He tapped the gavel. Court is adjourned until 2 p.m. for the motion hearing. As the spectators filed out, Ethan felt the weight of dozens of eyes on him. He slung his backpack over one shoulder, stepping aside so Ms. Jansen could pass. She offered a warm clap on his back. Very well done, Ethan. Outside the courtroom, the corridor buzzed with whispers. The courthouse coffee kiosk was crowded with reporters eager for a scoop. Teen Prodigy stuns judge. Headlines already forming. Ethan paused to let an older attorney pass. The man peered at him, incredulous. Son, you just embarrassed half the Bar Association in under 5 minutes. Ethan managed a small laugh. I just did my job, sir. The corridor emptied, and Ethan found himself alone under the fluorescence, his jacket suddenly too hot. Doubt flickered through his chest. He was still a teenager, unlicensed, inexperienced, yet he'd spoken with the authority and precision of a seasoned litigator. He'd held his own against a public prosecutor. He pressed a hand to his throat, his pulse pounded. He felt the rush of adrenaline, of possibility. In 3 hours, he'd stand before the same judge and watch him rule on that motion. Would the suppression succeed? Would he face ridicule? Or respect? Ms. Jansen returned, carrying 2 cups of coffee. Here, she said. You earned it. She handed him one. He inhaled the rich aroma, and it grounded him. Thank you, he said softly. He debated telling her how terrified he was that the judge would laugh him out of court tomorrow. Pride warred with insecurity. Ms. Jansen patted his shoulder. Ethan, you know the law better than most who've been practicing for 20 years. Trust your instincts. A tentative smile curved his lips. He nodded. The judge may mock him for showing up as a teenager. The prosecutor may try to undermine him. But in the next hearing, he would stand tall and let the law speak for itself. A hush fell over them both as the distant chime of the courthouse clock told noon. Ethan drew up his legal pad. He had 3 hours to reread every case, anticipate every counter-argument, and prepare his client's fate. His eyes shone with determination. This was his moment, his chance to prove that genius has no age requirement. And whatever happened in less than an hour, he would not be dismissed. Not by the judge, not by the prosecutor, and not, even now, by himself. Preparation and pressure. The midday sun beat down on the courthouse plaza as Ethan Parker and Miss Jansen retreated to the small conference room off the main corridor. The wood-paneled walls were lined with framed degrees and commendations, and the single window offered a limited view of the city's skyline. A battered coffee pot sat on a side table, its percolator still humming softly, though the coffee within had long since turned bitter. Ms. Jansen poured 2 fresh cups from an urn on the credenza. The rich aroma of roasted beans filled the cramped room. Ethan accepted his coffee with a steadying hand, setting it on the table beside his meticulously organized legal pad and an open binder containing his notes on Fourth Amendment jurisprudence. The folder's tabs were color-coded. Blue for constitutional provisions, yellow for state statutes, red for Supreme Court opinions, and green for deposition transcripts. Every piece of evidence and precedent had its designated slot. He closed his eyes for a moment, inhaling deeply before exhaling with determination. "You've got 90 minutes before we reconvene," Ms. Jansen reminded him, settling behind the conference table and flipping on her laptop. She had an attorney's practice composure. Lean posture, steady gaze, fingers hovering above the keyboard. Every line on her face spoke of years spent in courtrooms, negotiating plea deals, and delivering impassioned closing arguments. But when she looked at Ethan, her usual reserve softened into genuine pride. He nodded. "I've reviewed Rodriguez, Terry, and Carroll. I want to go over Hyen and Riley again, just to make sure I've got the nuances." Ms. Jansen tapped a few keys. "Here's the text of Hyen v. North Carolina, 2014. Remember, the plurality held that a reasonable mistake of law can still furnish reasonable suspicion. But it doesn't excuse prolonged detention once the initial justification ends. Then in Riley v. California, the court required a warrant for digital data on cell phones. We don't have phone searches here, but the concept is the same. The trooper's authority was strictly tied to the traffic violation." She pulled up highlighted passages on the screen. Ethan leaned forward, tracing the lines with his fingertip. "So, if he unreasonably extended the stop to ask about drugs, that evidence should be suppressed under Rodriguez. And Hyen doesn't help him, because there was no mistake of law defense raised. The trooper knew the headlight had been fixed by the time he ordered the defendant out of the car." "Precisely," Ms. Jansen confirmed. "Now, let's anticipate their counter-arguments. Expect them to argue that the trooper observed furtive movements, or that he smelled marijuana. We need to be ready to refute each point." Ethan scribbled notes in the margin. His handwriting was neat, almost obsessive. He looked up at Ms. Jansen. "What about demeanor? The prosecutor might stress the defendant's nervous behavior as corroboration of criminal conduct." Ms. Jansen closed the laptop, leaning back in her chair. "Courts have held that nervousness alone, especially during a traffic stop, cannot justify extending the detention. Everyone's nervous when a uniformed officer beckons them out of their car." She sipped her coffee. "But be prepared. They'll claim the totality of the circumstances includes demeanor, location, time of day. Maybe they'll even mention the defendant's criminal record. We need to show those factors, taken together, still fell short of reasonable suspicion." Ethan's eyes flicked to the courthouse clock. 1:15 p.m. He took another sip of coffee, grateful for the warmth. The initial adrenaline rush from Chapter 1 had given way to a slow, burning anxiety. His heart hammered against his ribs. He wasn't just participating in a moot court or a school competition. This was the real thing. His research, his carefully honed arguments, were now subject to the merciless scrutiny of a judge and a seasoned prosecutor. He tapped his pen. "Let's run through my outline one more time." They spent the next 20 minutes rehearsing. Ethan standing to deliver his points, Ms. Jansen interrupting with challenging questions, then switching roles so he could field likely prosecutorial retorts. He practiced his posture, straight back, even tone, measured pace. He refined his opening sentences. "Your Honor, the state's continued questioning of Mr. Reynolds after correcting the taillight constituted an unlawful expansion of a consensual encounter into a detention." With each run-through, his confidence grew. His voice solidified. His gestures became more natural. By 1:45 p.m., he was delivering his argument with the fluency of someone who had studied the law for years, rather than mere months. Ms. Jansen offered a genuine smile. "You're ready," she said. "Go in there and do what you do best." Ethan packed his binder, slid his laptop into his backpack, and shouldered the weight of the violin case. He paused at the threshold, looking back at Ms. Jansen. "Thank you for trusting me, for mentoring me." She waved him off. "You earned this, Ethan. Just remember, it's not about dazzling with big words. It's about clarity, logic, and adherence to precedent. Speak for the Constitution, and the court will listen." He nodded. She had given him the tools. Now it was up to him to wield them. As he stepped out of the conference room, the hallway's fluorescent lights felt blinding. A group of law clerks hurried past, their chatter hushed but curious glances aimed in his direction. The courthouse staff whispered, "That's the kid. The Prodigy." He imagined the headlines waiting to pounce. Teen genius advocates sabotage speeding case. A knot tightened in his stomach. He rounded the corner to courtroom 3B just as the bailiff opened the door for him. The room was half full. The judge's clerk sat typing into the record. The prosecutor consulted quietly with her investigator. A handful of spectators remained, including a local reporter taking notes. Ms. Jansen was already by the counsel table, offering a reassuring nod. Judge Montgomery's gaze flicked up. The portly jurist still looked skeptical but noticeably less amused than before. He cleared his throat. "Mr. Parker, are you ready to proceed?" Ethan swallowed, placed his binder on the counsel table, and rose. He forced a calm breath. Outside, the world seemed to hold its breath with him. He met the judge's eyes. "Yes, Your Honor." Judge Montgomery inclined his head. "Very well. Let us hear argument on the state's response to the motion to suppress." Ethan stepped forward, adjusting his tie. He had rehearsed every word. And now, it was time to put it into action. His mind raced through the outline, but his voice remained steady. "Your Honor, the central issue today is whether the troopers' continued questioning of Mr. Reynolds, after rectifying the taillight violation, exceeded the scope of a lawful traffic stop under the Fourth Amendment. In Rodriguez v. United States, the Supreme Court held." As the words flowed, Ethan felt the earlier tension melt away. Each citation landed with precision, each point built upon the last in a seamless mosaic of legal reasoning. He maintained eye contact with the judge, unflinching, respectful. Across the table, Prosecutor Reynolds watched him with scrutiny, her lips pressed into a line. When he concluded with his final plea, "Accordingly, the evidence obtained after the initial traffic stop must be suppressed." He closed his binder and stood waiting, heart pounding but conviction undimmed. Judge Montgomery leaned forward, tapping his pen. He regarded Ethan with a new regard, one born not of mockery, but of genuine professional curiosity. The courtroom seemed to exhale as Ethan returned to his seat. For a moment, silence hung between them. Then Ms. Jansen gave him a discreet thumbs up. Ethan allowed himself the briefest of smiles. He had faced down his own doubts, and the doubt of the bench, and emerged speaking the language of justice with clarity and authority. Whatever the judge's ruling, Ethan knew he'd crossed an invisible threshold today. He had proven that intellect and preparation could transcend age. And in that moment, as the afternoon light filtered through the courtroom windows, he felt more certain than ever. This was where he belonged. The judge's ruling in ripples, the late afternoon sunlight streamed through the high-arched windows of courtroom 3B, casting long warm beams across the polished wooden pews. Ethan Parker sat at the defense table, his binder open but untouched, his posture taut with anticipation. At his side, Ms. Jansen reviewed a copy of the prosecutor's opposing brief. Her brow furrowed not with concern, but the focused intensity of a seasoned litigator tuning her strategy. Across the aisle, Prosecutor Dana Reynolds tapped her pen impatiently, her crisp shoes clicking against the floor as she shifted in her chair. Judge Montgomery entered precisely at 4 o'clock, the gavel thundering once against the sound block. The room hushed, the only sound the distant hum of the air conditioning. The judge's expression was inscrutable as he donned his glasses and consulted his notes. Ethan felt his pulse spike. He recalled the confident precision of his argument just hours earlier, how he cited precedent after precedent, how his voice had carried the authority of careful reasoning. But now the question loomed. Would the judge's written ruling vindicate his work, or dismiss it as youthful overreach? "Counsel," Judge Montgomery began, voice measured. "I have considered the arguments on both sides regarding the motion to suppress evidence obtained after the initial traffic stop in State v. Reynolds. Let me summarize my findings." He paused, adjusting his glasses. Ethan leaned forward, every fiber alert. "The Fourth Amendment protects individuals from unreasonable searches and seizures," the judge intoned. "And the Supreme Court has established clear boundaries for permissible scope of a traffic stop. In Rodriguez v. United States, the court held that once the purpose of a traffic stop is fulfilled, here, the correction of the malfunctioning taillight, Any further detention for unrelated inquiries constitutes an unreasonable seizure. He glanced at the prosecutor. The state contends the trooper developed reasonable suspicion of criminal activity, citing the defendant's nervous demeanor, furtive movements, and the time of night. However, the record shows the trooper did not observe any contraband or weapons before extending the stop. The dashcam footage reveals Mr. Reynolds' hands were visible, his movements consistent with normal attempts to adjust his jacket under the glow of the patrol car lights. Nervousness alone, without additional corroborating circumstances, cannot satisfy the reasonable suspicion standard. Judge Montgomery nodded slightly, as though reinforcing his own words. Ethan felt a stirring of hope. The judge continued. Moreover, the trooper failed to articulate specific facts supporting an individualized suspicion of wrongdoing. The fact that Mr. Reynolds is a convicted felon, though relevant to sentencing, does not justify suspicion absent evidence of probation violation or other legitimate cause during a routine traffic stop. Ethan glanced at Ms. Jansen. She offered a tiny, almost imperceptible smile. The judge's narrative aligned exactly with Ethan's argument. Therefore, Judge Montgomery concluded, I find the trooper departed from the permissible scope of the traffic stop when he continued to question Mr. Reynolds beyond the time necessary to address the taillight violation. Consequently, any evidence obtained after the correction of the headlight violation is suppressed. He rapped his gavel. Motion granted. A murmur rippled through the courtroom. Prosecutor Reynolds rose immediately. Your Honor, with respect, may I request a brief sidebar? I wish to discuss the potential impact on our subsequent proceedings. Granted, the judge replied. He signaled the bailiff to clear the area near the bench. Ethan and Ms. Jansen shared a glance. This was standard procedure, but it also meant the state was considering its options. At the bench, the prosecutor leaned forward, voice lowered, but urgent. Your Honor, given the suppression of the evidence on which we intended to file charges for possession of a controlled substance, we request leave to file a new charging document on alternative grounds, specifically possession of drug paraphernalia, based on the trooper's subsequent plain view observation of a glass pipe on the passenger seat. Judge Montgomery tapped his pen. Ms. Jansen? Ms. Jansen rose, composed. Your Honor, the glass pipe was not discovered until the defendant was already unlawfully detained. Under the fruit of the poisonous tree doctrine, evidence obtained as a direct result of an unconstitutional seizure must also be excluded. Therefore, we object to any further charges based on that evidence. Prosecutor Reynolds pressed her lips together. After a moment's thought, Judge Montgomery nodded. I agree. The plain view exception applies only when an officer is lawfully present and observes incriminating evidence in plain sight. Here, the trooper's continued detention was unlawful. Therefore, the subsequent observation of the pipe is tainted by that illegality. He straightened. No additional charges may be brought based on that evidence. Court is adjourned. The gallery erupted in whispered astonishment. Reporters furiously tapped notes into recorders. Ethan felt his chest expand with relief and pride. He had not only survived his first court appearance under fire, but his argument had prevailed, upholding constitutional protections for his client. As spectators filed out, Ms. Jansen patted Ethan's shoulder. Remarkable work, Ethan. You held strong and spoke with clarity. Ethan slung his backpack over his shoulder, still processing the judge's words. He had entered the courtroom as a nervous teenager and emerged a victorious advocate. But while the suppression ruling was a milestone, he knew this was only the beginning. The Reynolds matter was resolved, but his future in law was just starting to take shape. Outside the courthouse, the late afternoon air was cooler, and the hustle of downtown traffic felt distant. Ms. Jansen guided Ethan to a bench under a shady oak tree. We should debrief, she said. The suppression of evidence secures your client's release on the pending charges. Now, our next step is to prepare for any potential civil rights claims Mr. Reynolds may have against the trooper and the department. This experience has broader implications. Ethan nodded, processing the layers of strategy. He opened his binder. I want to draft a memorandum on the scope and limitations of the plain view exception under Fourth Amendment jurisprudence. Also, I'd like to outline potential claims under Section 1983 for unlawful detention and false arrest. Ms. Jansen glanced at her watch. Good plan. You'll want to examine case law on damages and qualified immunity. But first, let's celebrate today's victory. How about I buy you dinner? Ethan closed his binder. He felt a mixture of elation and fatigue. Dinner sounds great. They walked toward the courthouse exit, passing the coffee kiosk Ethan had hardly noticed that morning. As he passed, the barista handed him a cup of iced tea, courtesy of a local law journal's editor who'd been covering the case. The act was simple but suffused with meaning. His work was noticed and respected. That evening, after filing his initial drafts and responding to editor emails praising his analysis, Ethan sat at his desk in his small bedroom, violin case leaning against the wall. He gazed at his law school acceptance letters pinned above his desk. Early admits from top programs, a testament to his intellectual gifts. Yet now, more than any letter of acceptance, the judge's ruling lay heavy in his thoughts. That moment in the courtroom had validated his dream, to use the law as a shield for the vulnerable. He opened his laptop and began typing his memorandum, the words flowing easily. The rubric he followed, issue, rule, application, conclusion, felt as natural as breathing. As digits blurred into paragraphs, he allowed himself a quiet smile. Today's victory belonged to his client, to constitutional order, and to his own evolution from student to advocate. Night settled outside, and the street lamps glimmered through his window. Ethan paused, set down his glass of iced tea, and lifted his violin. He drew the bow across the strings, filling the room with warm, resonant notes. Music, like the law, demanded discipline and creativity in equal measure. He closed his eyes and played through his favorite concerto, each movement echoing the resolve that had carried him through the day. Tomorrow, the city would wake to headlines proclaiming teen attorney triumphs in court. But Ethan knew beyond the sensationalism lay a deeper truth. Every person, spotlight and sacrifice. The Monday morning bell rang through Jefferson High School's cavernous hallways. But for Ethan Parker, the sound registered more as a reminder of looming obligations than a cue to gather books and head to class. He stepped off the crowded bus with his violin case slung over one shoulder and his backpack over the other, both feeling heavy, one with wood and strings, the other with statutes and briefs. As he navigated past clusters of chattering classmates, he sensed more than the usual undercurrent of teen gossip. Today, the air crackled with rumors of the courtroom prodigy. In the cafeteria, a group of students clustered around a table, whispering and pointing at him. He avoided eye contact, sliding into an empty seat at the back. His friend Carla Reyes slid in beside him, dropping her tray with a soft clatter. "Ethan, I saw the headlines," Carla said quietly, nodding toward a student's phone screen. "Teen genius wins suppression motion." Ethan forced a smile. "Yeah, I saw that," Carla scowled. "That's incredible, but, you okay?" He sighed, tracing the wood grain of the table. "It's weird. I feel proud, but it's like everyone expects me to be a legal savant now, 24/7. I still have a physics test today and I haven't studied." Carla reached over, squeezing his hand. "You'll ace it. You're the smartest person I know. Even if you do spend half your night drafting memoranda." He chuckled, though nerves knotted in his stomach. "Thanks." He pulled out flashcards and tried to focus on Newton's laws, but his mind drifted to the day ahead. The physics exam during third period, orchestra rehearsal after school, then dinner prep for his mom before late-night drafting of the civil rights complaint. His schedule resembled a carnival plate spinners, one wobble, and everything crashed. At 10:15 a.m., Ethan sat in Mrs. Caldwell's physics class, scribbling F equals MA across the margin of his notebook. But the teacher's lecture on inclined planes became background noise. His phone buzzed in his pocket. An email notification. He resisted the urge to check it, focusing instead on solving for the acceleration of a block sliding down a 30-degree ramp. The equation was straightforward, but suddenly his mind replayed Judge Montgomery's voice, affirming his constitutional reasoning. After the bell, Ethan dashed to his locker for a swig of water and reviewed his flashcards for the upcoming test. He slipped into the exam room 2 minutes before the first question appeared. The typed problems blurred at first, kinetic energy, momentum conservation, until he squinted and recognized a familiar formula. His pen flew across the paper. When the proctor collected the tests 20 minutes later, Ethan exhaled. He strode down the hallway toward the library, clutching his violin case. Next was orchestra rehearsal in the music wing. The orchestra director, Mr. Bernstein, had scheduled a sectional to prepare for the spring concerto competition. Ethan's violin solo was demanding, requiring precise spiccato and seamless bow control. He settled into his seat and began running scales, the rich resonance of the instrument replacing the legal and scientific thickets in his mind. That afternoon, Ethan met Ms. Jansen at the law clinic located off-campus in a converted brownstone near downtown. The vaulted ceilings and dark oak bookcases lent the space a scholarly gravitas. Ms. Jansen greeted him with a stack of case files. "I've drafted the Section 1983 complaint for unlawful detention and false arrest. I need your input on factual allegations. Your eyes caught relevant timestamps in the dashcam footage." Ethan set aside his violin and pulled out his color-coded binder. He reviewed the chronology: the initial traffic stop at 8:15 p.m., the headlight repair at 8:25 p.m., the extended questioning until 8:40 p.m., and the discovery of the pipe at 8:41 p.m. Each minute equated to a constitutional violation. Ms. Jansen watched him annotate the draft. "This is excellent. If we can show the trooper knew, or should have known, that extending the stop was unlawful, then we clear the hurdle for a qualified immunity defense challenge." He nodded, mentally rehearsing the legal standards. But outside the window, a troop of city buses rumbled past, reminders of the everyday lives that circled around these high-stakes legal battles. When they finished, Ms. Jansen glanced at the clock. "It's already 6 p.m. You have orchestra tonight?" Ethan rubbed his eyes. "Sectional runs until 7:30. I'll head straight there." "You're burning the candle at both ends." "I know," he admitted, "but I want to get this right." She clasped his shoulder. "You're making a real difference. Just remember to pace yourself." At 7 p.m., Ethan arrived at Stonebridge Community Hall, where the All-City Youth Orchestra rehearsed. He crept inside, careful not to disturb the final measures of Tchaikovsky's Serenade for Strings. The conductor nodded at him. He slipped onto the first-chair violin stand. For the next 90 minutes, Ethan immersed himself in music. His bow danced across the strings, each phrase an antidote to legal briefs and physics equations. When the rehearsal ended, he lingered to practice his solo one more time in an empty auditorium. The polished wooden floor reflected his foot-tapping pulse. The still warm lights overhead illuminated his concentration. But fatigue tugged at his eyelids. He packed his violin and stepped outside into the cool spring air. The sky had darkened, and street lamps cast pools of yellow light on the pavement. Ethan checked his phone. 8:45 p.m. He looked back at the hall doors, then at the distant glow of his street's lampposts. His mother expected him home to help prepare dinner, but he still needed to draft the final section of the complaint. He bit his lip. A football game on a neighbor's TV drummed through an open window. Carla's voice on his answering machine cut through the noise. "Ethan, you okay? Haven't heard from you all day. Call me." He pocketed the phone and unlocked his bicycle. The night air whipped past his face as he pedaled home under the intermittent glow of streetlights. At home, he greeted his mother in the kitchen as she juggled pots and pans. He chopped vegetables for soup, his mind still replaying the day's arguments and musical passages. Dinner was quiet. His mother asked about school, he answered about physics, orchestra, and the upcoming complaint. She admired his poise but noticed the dark circles under his eyes. "You're overworking yourself, son." He managed a reassuring smile. "I'm okay." After dinner, he retreated to his desk, violin case leaning against the wall like a faithful companion. He opened his laptop and reviewed the draft one last time. His fingers flew over the keys, refining language, inserting citations, ensuring every fact aligned with the record. 2 hours later, he hit send to Ms. Jansen, then sank back in his chair. His eyes closed for a moment, and he felt the ache of fatigue, but also a profound sense of purpose. He had navigated physics formulas, musical complexities, and constitutional doctrines all in one day. His life had become a delicate balance of scholarship, artistry, and advocacy. He rose, stretched, and peered out his window at the silent street below. The courthouse steps, where he'd stood just days ago, seemed distant now. Yet they remained an anchor for his ambitions. He returned to his desk, fetched his violin, and played a single clear note into the stillness. Tomorrow would bring new challenges, a full draft of the complaint to file, a meeting with Mr. Reynolds to discuss civil remedies, and another round of classes and rehearsals. He knew he couldn't sustain this pace forever. But in that moment, as the final note lingered in the quiet, he resolved to continue. For Ethan Parker, age 17, had discovered that sacrifice was the currency of change, and he was rich in conviction. And as the last echo of his violin faded into the night, he whispered to himself, "One more day. One more step. Crossroads and consequences." The following morning dawned crisp and clear, the pale sun casting long shadows over Franklin County. Ethan Parker rode his bicycle the 2 miles to the courthouse, his backpack heavier than usual with fresh drafts of the Section 1983 complaint and supporting exhibits. At 17, he was accustomed to carrying more responsibility than most of his classmates, but today, his shoulders felt especially burdened. Today, he would meet with Mr. Samuel Reynolds to discuss the civil rights suit, a meeting that would solidify Ethan's role not merely as a legal researcher, but as an advocate entrusted with another person's fate. He arrived at the courthouse side entrance precisely at 8 o'clock. The marbled walls loomed above him as he climbed the steps. Inside, the corridors were already abuzz. Parade of attorneys, clerks, and litigants heading to morning dockets. Ethan made his way to the public defender's office, where Miss Jansen waited in her corner office. The smell of fresh coffee lingered in the air. "Good morning," she greeted him with a warm smile. "Mr. Reynolds will arrive shortly. Have you reviewed the complaint and exhibits?" Ethan placed his binder on the narrow conference table. "Yes. I tightened the factual chronology, added exhibit numbers to the dash cam stills, and clarified the legal standards under Manel for municipal liability." "Excellent," Ms. Jansen said. "He'll appreciate the attention to detail." Moments later, the door opened and Mr. Reynolds entered, flanked by the clinic's social worker. Dressed in a rumpled jacket and jeans, Reynolds carried a folder bursting with personal photographs and character references. He was no longer handcuffed or under suspicion. His criminal charges had been dismissed, but the indignity of the unlawful stop still weighed on him. Ethan stood as Reynolds stepped forward. "Mr. Reynolds, it's good to see you under better circumstances." Reynolds extended his hand and shook Ethan's firmly. "Thank you for everything you've done so far." His voice was steady, though tired. "I brought some photos and letters from friends who'd like to testify about how this incident affected me." Ethan nodded. "That will be helpful to establish damages. This complaint contains claims for unlawful detention, false arrest, and municipal liability for inadequate training. We'll seek compensatory damages for emotional distress and attorney's fees." Reynolds sank into the chair, facing them both. "I'm relieved the suppression motion succeeded, but I still feel violated. I couldn't sleep for nights after, imagining being treated like a common criminal." He paused, folding his hands. "I just want to make sure this never happens to someone else." Ms. Jansen exchanged a glance with Ethan. "That's precisely why we pursue Section 1983 claims, not just for compensation, but to prompt police departments to change policies and training." Reynolds leaned forward. "I trust you too. Let me know how I can help." Ethan stored the photographs and letters in a new folder. "We'll file the complaint today. You might receive a request for a deposition notice or settlement discussions. I'll draft your declaration for you to review tonight." After Reynolds left, Ethan exhaled. "That felt significant." Ms. Jansen nodded. "You're becoming the face of this case. Clients will look to you for answers. It's a big responsibility." Ethan swallowed. "I know. I want to do right by him." By late morning, Ethan had filed the complaint with the county clerk's office, affixing the official stamp to the first page. He and Ms. Jansen returned to her office to plan next steps. "We should send a demand letter to the county attorney," she suggested. "Often that spurs early settlement, but if they refuse, we prepare for discovery." Ethan tapped his pen. "I'll draft the demand letter, citing our claims and proposing mediation within 30 days. I'll also outline our willingness to proceed to trial if necessary." As he worked, his phone buzzed with a news alert. Local teen attorney takes on police department in civil rights suit. He clicked the article, which quoted his arguments and praised his legal acumen. Scrolling further, he saw the comments section. Some lauded him as a hero. Others sneered at his youth, calling him arrogant or unqualified. A thrill of vindication pulsed through him, and then a prickling of unease. He was proud of his work, but he was still a teenager. Public acclaim felt surreal, and public criticism stung. He deleted the app notification, forcing himself to focus on the demand letter's precise language. That afternoon, his high school buzzed with excitement and envy. In the hallway before chemistry class, a group of students blocked his path. "Hey, genius," one called. "Can you fix my lab report? Or argue for my physics extra credit?" joked another. Ethan managed polite smiles and waved through, but his hands trembled. He valued his friendships with Carla and a few others, but the corridors now felt like a labyrinth of expectations and judgments. In chemistry, Dr. Patel launched into a lecture on reaction kinetics, but Ethan's mind wandered to the county attorney's office and whether they'd adhere to the 30-day window. He scribbled notes in the margin of his notebook. Follow up on mediation schedule. Draft interrogatories. After school, Ethan headed to the community law clinic to finalize the demand letter. He found Ms. Jansen on the phone, pacing. "It's the county attorney," she said, hanging up. "They're open to discussion but won't mediate without preconditions. Require us to stipulate that the trooper acted in good faith. That undermines our claims." Ethan frowned. "We can't concede good faith. It's the core dispute, whether the trooper's actions were objectively reasonable." She nodded. "Write a reply declining their precondition and reiterating our proposal." He opened his laptop and composed a firm but professional email, attaching the original demand letter. After reading it aloud to Ms. Jansen, who approved, he clicked send. The clock read 6:15 p.m. That evening, Ethan returned home, drained but restless. His mother greeted him in the kitchen. "You're late. Dinner's cold." He apologized, microwaving his meal. As he ate, his phone buzzed again. A text from Carla. "Study group at my place tomorrow. Physics and chemistry don't bail." He typed, "I'll be there," and set the phone aside. Upstairs in his room, he spread out the day's work, the final complaint draft, the demand letter thread, and notes for a deposition outline he'd begin tomorrow. He glanced at his violin in the corner, silent, waiting. Guilt and fatigue hardened in his chest. He opened his laptop and began drafting interrogatories to serve on the county and the trooper, demanding documents, policies, training manuals, personnel files. The rhythm of keystrokes soothed him, but shadows lengthened outside his window, reminding him it was past midnight. At last, he leaned back and rubbed his eyes. The room was quiet except for the hum of his laptop. He saved his work and sent it to Ms. Jansen for review. As he closed his laptop, he thought of Mr. Reynolds waiting for justice, and of the children and elderly who might one day benefit from improved policing practices. The weight of those potential futures lent him strength. He picked up his violin, drew the bow, and played a slow, haunting melody. Each note seemed to carry his hopes and fears, weaving them into music he both understood and transcended. When the final note faded, Ethan set down the violin and closed his eyes. Tomorrow would bring chemistry equations and county objections, but for now, he allowed himself a moment of quiet reflection. He whispered into the darkness, "Every action has consequences. Yours, mine, theirs. I'll carry them responsibly." And with that solemn vow, he extinguished his desk lamp, surrendering to the promise and uncertainty of the days ahead. Discovery and doubt. The following week dawned unseasonably warm for autumn, and the courthouse parking lot buzzed with more activity than usual. Ethan Parker arrived early, his backpack laden not with violin sheet music but with stacks of legal documents. The complaint, demand letter correspondence, draft interrogatories, and a newly filed notice of deposition. Today marked the first salvo of formal discovery in Reynolds versus Franklin County, and Ethan would play a central role. He met Ms. Jansen at the defense table in Courtroom 2A. The judge assigned to oversee discovery motions, Judge Elwood, was a stickler for procedure and punctuality. As they conferred in hushed tones, Ethan tapped out final edits on his laptop. Clarifying definitions in interrogatories, tightening requests for production, and framing requests for admissions to challenge the county's defenses. At 10 o'clock, the clerk announced, "Case called, Reynolds v. Franklin County, discovery motions." Judge Elwood entered, nodded curtly, and surveyed the parties. On the plaintiff's side, Ethan and Ms. Jansen leaned over their files. On the defense side, a county attorney and 2 deputies sat at the government table. Judge Elwood began, his tone brisk. "We have several motions: plaintiff's motion to compel documents and to shorten time for responses, and defendant's motion for a protective order. Counsel, be succinct." Ms. Jansen rose. "Your Honor, plaintiff respectfully moves to compel Franklin County to produce comprehensive training manuals, internal memoranda regarding traffic stop procedures, body-worn camera footage policies, and personnel files related to Officer Bradford, the trooper involved in Mr. Reynolds' detention." She paused. "We also request that responses be served within 14 days, given the public interest and the timeline for potential trial scheduling." Ethan watched the county attorney, Mr. Fields, frown as he reviewed the motion papers. When his turn came, Fields stood with a practiced air. "Your Honor, the county has produced redacted policy manuals and a privilege log for internal communications. We object to unredacted release of internal deliberations, which are protected by deliberative process privilege. We request that the court issue a protective order limiting disclosures." Ethan felt a jolt of apprehension. The deliberative process privilege could shield key documents, hindering their ability to show systemic flaws. He exchanged a glance with Ms. Jansen, who gave him a reassuring nod. Judge Elwood set his glasses on the bench and peered down. "I will take these motions under advisement and issue a ruling by the end of the week. Meanwhile, I order the county to produce unredacted versions of any training materials directly related to roadside stops and body camera policy. Other materials may be logged. Responses to plaintiff's discovery requests are due in 14 days. Court is adjourned." The gavel fell, and Ethan exhaled. He and Ms. Jansen packed their papers. "Not perfect," she murmured, "but we'll get what we need for now." Later that afternoon, Ethan returned to the law clinic, where a conference room awaited their first deposition. Mr. Reynolds had agreed to testify about his experience. The plaintiff's deposition would serve 2 purposes: to memorialize his testimony and to build a timeline for trial. Ethan arrived early to set up microphones, notepads, and printed copies of the complaint. Mr. Reynolds looked calmer than the first time Ethan saw him, no longer anxious about criminal charges, now invested in securing accountability. He greeted Ethan with a warm handshake. "Mr. Reynolds, thank you for coming. We'll begin with me as your counsel. Then you'll be asked questions by the county attorney. If at any point you're uncomfortable, let me know." Reynolds nodded. "I'm ready." Ms. Jansen swore in Mr. Reynolds on the affidavit. Ethan sat beside her, legal pad poised. The county attorney started with background: name, address, employment history. Then comfortably segued, "On July 14th, 2025, did you consent to the trooper's further questioning after your headlight was repaired?" Reynolds's voice was steady. "Number Y believed I was free to go, but he kept me talking." Ethan listened, pen moving. The defendant described his subjective fear: being held at night on an unfamiliar highway, handcuffs clicking as the trooper ordered him out of the car. He recounted the indignity of pat-downs and the chill of uncertainty. At one point, the county attorney pressed, "Did you attach significance to being a convicted felon? Don't you think that influenced the trooper's suspicion?" Reynolds's jaw tightened. "I shouldn't be punished now for mistakes I made years ago." Ethan noted the emotional resonance. He recognized that searing personal testimony could move a judge or jury. After Reynolds's deposition, Ethan and Ms. Jansen drank mug after mug of strong coffee, reviewing transcripts. "We'll use his testimony to oppose any privilege claims," Ethan observed. "He describes training gaps and unreasonable stops." Ms. Jansen agreed. "Exactly. And we'll introduce the body camera policy as evidence he should have been warned about his rights." That evening, at Jefferson High School's mock trial club meeting, Ethan found himself both mentor and peer. He coached novices on closing arguments and taught them the difference between direct and cross-examination. Afterward, a classmate, Ben Thompson, approached him. "Ethan," Ben said, "I heard they filmed you at court. There's a video online of you arguing before Judge Montgomery." Ethan winced. "Yeah, I know." "You were amazing," Ben said, "but you looked nervous." Ethan nodded, suddenly self-conscious. "I felt nervous, and nervous today too, during the deposition. Mr. Reynolds' story. It got to me." Ben shrugged. "So what? It's part of being a lawyer. You do it with empathy, right?" Ethan nodded slowly. "Right." Back home, Ethan reviewed his email late into the night. The court's ruling on discovery was posted. A partial win. The county had produced manuals but refused internal emails about policy debates. Ethan drafted a motion to compel those emails, arguing the deliberative process privilege must yield when constitutional rights are at stake. He paused, fingers on the keyboard. Doubt flickered. Was it ethical to pry into private deliberations? Would he overreach and damage his credibility? He tapped the screen. The trooper's actions had been harmful. If internal communications revealed awareness of the risks, those emails were essential. His uncertainty hardened into resolve. He finished the motion, citing in resealed case and EPA v. Mink on the limits of privilege in civil rights actions. He attached a red line of requested documents. Then he sent it to Ms. Jansen. As the clock struck midnight, Ethan leaned back with exhaustion. The road ahead was fraught. More motions, depositions of troopers and supervisors, possible motions for summary judgment. Each step demanded rigorous research and emotional resilience. But as he switched off his lamp, he recalled Mr. Reynolds' calm demeanor, his quiet dignity. He recalled Judge Montgomery's nod of respect in that first hearing. And he remembered Judge Elwood's careful safeguarding of discovery. Within the tension between procedure and principle lay the promise of justice, if only he could navigate the complexity without losing his moral compass. He rose, stretched, and closed his laptop. Outside, the night was silent. Within him, however, questions still stirred. Could a teenager truly bear the weight of constitutional accountability? As he extinguished the lamp, he vowed to find out. One document request, one deposition, and one courtroom at a time. Confrontation in the depositions and the calm before the storm. The morning sun filtered through the blinds of the Franklin County Law Library, painting horizontal stripes of light across the long oak table. Ethan Parker arrived with a slender laptop bag slung over one shoulder and his leather-bound deposition outline in his hand. Today was crucial. The defense had noticed several of the plaintiff's interrogatories and, in turn, served deposition notices for both Officer Bradford and the police chief, Margaret Hayes. Ethan's role was to prepare Mr. Reynolds' responses and attend both depositions alongside Ms. Jansen, ensuring that the defense could not bury their own potential misconduct under layers of privilege. He found Ms. Jansen in the corner, reviewing a stack of exhibits, training manuals, dashcam footage stills, and copies of the demand letter. She greeted him with a nod. "Bradford's deposition is at 10. Hayes's is at 2:30. Let's go over our questions one more time." They spread out the deposition outlines. Ethan's side grouped questions into categories. 1. Procedural training. 2. Body camera policy. 3. Scope of traffic stop authority. And 4. Subjective knowledge of constitutional rights. Each question had sub-questions and follow-ups. "What will you ask Chief Hayes?" Ms. Jansen prompted. Ethan glanced at his notes. "I want her to confirm whether the department's training explicitly covers the point at which a traffic stop must end, when the violation is corrected. If she refuses, we'll ask about any demonstrations or memos. Also, if there have been prior complaints or discipline related to extending stops." Ms. Jansen tapped her pen. "Exactly. And if she invokes deliberative process privilege, we'll ask about non-privileged policy statements. We need to force the department to choose between hiding systematic flaws or exposing them." Ethan closed his notebook. "Let's do it." 10 a.m. Officer Bradford's deposition. The conference room was stark. Beige walls, fluorescent lighting, and a single large table. Officer Bradford entered in his crisp uniform, chest neat with badge and name tag. He took the witness seat across from Ms. Jansen. Ethan sat beside her, heart pulsing in his throat. Ms. Jansen began with routine background questions. Bradford's years of service, training academy details, and specialized courses. Each answer was precise, but delivered with a hint of formality. When she turned to the key questions, Bradford's posture stiffened. "Officer, were you trained on the parameters for extending a traffic stop beyond the initial violation?" Bradford cleared his throat. "Yes, ma'am. But it's ultimately discretionary. The manual says you can ask follow-up questions if you develop reasonable suspicion." Ms. Jansen waited, pencil poised. "Specifically, did your training materials, Policy Manual Section 3.4, define reasonable suspicion, or list examples of permissible post-violation inquiries?" Bradford shuffled through his binder. "It defines it in legal terms, consistent with Fourth Amendment standards, but examples are limited to weapons or visible contraband." Ethan leaned forward. "Officer Bradford, at what point did you deem Mr. Reynolds to be suspicious of drug possession? Did you articulate specific facts supporting that belief?" Bradford's jaw tightened. His nervous demeanor, the time of night, and when he exited the vehicle, I detected a faint odor of marijuana. Ethan's pen stopped. The odor claim was new. "Officer, did your dashcam or bodycam audio record that odor detection?" Bradford hesitated. "No, sir. Odor analysis isn't recorded." Ethan exchanged a glance with Ms. Jansen. This smelled like the trooper's attempt to justify his actions after the fact. He asked a follow-up. "Did you document the odor detection anywhere in your report?" Bradford's eyes flicked away. "No, ma'am." Ms. Jansen pounced. "Isn't it true that you routinely document odor detection when it forms the basis for extended detention?" Bradford coughed. I may have been tired that night." The admission caused a hush. Ethan felt a surge of vindication. The trooper had acted on an undocumented odor he couldn't prove, and had not mentioned at the suppression motion. His conduct looked all the more reckless. Ms. Jansen thanked Officer Bradford and excused him. Ethan sank back, adrenaline still coursing. 2:30 p.m. Chief Hayes' deposition. After a late lunch, Ethan and Ms. Jansen returned to the same room for Chief Hayes' deposition. Hayes, a steely woman in her 50s, exuded authority. She settled into the witness chair, arms folded. Ms. Jansen opened with department structure and budget questions, easing into policy inquiries. "Chief Hayes, does the Franklin County Sheriff's Department training manual explicitly state when a traffic stop must end?" Hayes paused. "Basic training covers the need for articulable suspicion. Specific timing is left to officers' judgment." Ethan interjected. "So there is no departmental requirement to cease questioning when the initial violation, here, a defective taillight, is corrected?" Hayes shook her head. "Number officers receive legal training but are not given detailed checklists." Ethan continued. "Have there been prior civil rights claims alleging unlawful detention by this department?" Hayes' lips tightened. "One in 2018, dismissed as frivolous." "Dismissed for lack of evidence, correct?" "Correct." Ethan leaned forward. "Are you aware of any internal memos or discussions, privileged or otherwise, reviewing officer discretion in traffic stops?" Hayes hesitated. "Internal emails are protected, but I'm not aware of any specific to that topic." Ethan pressed on. "If such emails exist, would you produce them?" Hayes' composure faltered. "I would have to consult counsel." The room crackled with tension. Ms. Jansen closed her notebook. "Thank you, Chief." As Hayes exited, Ethan felt the weight of their answers. The department lacked clear guidance, had no oversight for post-violation questioning, and hid internal deliberations behind privilege. That evening, Ethan returned home, weary. He reviewed the deposition transcripts, annotating key admissions. Undocumented odor, lack of policy specificity, and prior internal inquiries. These would form the backbone of their next motion to compel privileged materials and to oppose summary judgment. He sensed unease settling in his chest. The defense would soon file motions contending that the trooper acted in good faith and that the department's lack of policy was not their liability. They would try to pin blame on Perez, the accused, and on isolated mistakes rather than systemic failures. He opened his laptop and drafted the motion to compel internal communications and to deny summary judgment. The memorandum cited Pearson v. Callahan on qualified immunity and Graham v. Connor on objective reasonableness. He argued that the trooper's undocumented odor claim and unarticulated suspicion precluded a finding of good faith immunity. He demanded that the court evaluate the trooper's actions under a clear legal standard, not leave it to personal discretion. As the clock ticked past midnight, Ethan paused. The narrative he'd constructed, of relentless research, tireless depositions, and unearthing injustice, was nearing its culmination. Next week, they would appear before Judge Elwood on summary judgment motions. He reclined in his chair, closing his eyes. Doubt had crept in during Chapter 6, but today's confrontations had restored his confidence. The truth was emerging. A pattern of constitutional violations, systemic ambiguity, and personal courage. Tomorrow he would meet with Mr. Reynolds to prepare him for potential trial testimony. Then he'd attend his physics midterm review and orchestra rehearsal. The pressure would mount, but Ethan was ready. He reached for his violin, drawing the bow across the strings. The warm tone filled the silent room, a reminder that, in both law and music, discipline and passion must coexist. And as the last note faded, Ethan opened his eyes to the glow of his laptop screen, fingers poised on the keyboard. Chapter 8, Resolution, lay ahead. But tonight, he savored the knowledge that he had faced the defense's fiercest weapons, their own silence, privilege claims, and self-justifications, and unveiled them under oath. Justice, he realized, was not merely a question of right and wrong, but of ensuring that truth could pierce the protective armor of power. And with that conviction steady in his heart, Ethan Parker prepared for the final act, vindication and new beginnings. The morning sun filtered through the tall windows of Courtroom 2A, illuminating the polished mahogany of the judge's bench and the rows of empty spectator seats. Today was the culmination of months of toil, the hearing on the county's motion for summary judgment in Reynolds v. Franklin County. Ethan Parker arrived early, clutching a neatly organized binder containing his opposition brief, key deposition excerpts, and highlighted training manuals. He felt the familiar thrill of anticipation mingle with fatigue, the product of sleepless nights spent drafting motions, mentoring Mr. Reynolds, and balancing school and orchestra commitments. Ms. Jansen met him at the counsel table. Her calm confidence anchored him. She laid out a printed copy of his argument summary. The trooper's unlawful extension of the stop, the undocumented odor claim revealed in deposition, the department's lack of clear policy guidance, and the qualified immunity doctrine inapplicable where rights were clearly established. Ethan reviewed the page one last time, committing each point to memory. At precisely 10 o'clock, the bailiff announced the proceedings. Judge Elwood entered, settling into his bench seat with a deliberate air. The county attorney stood to argue first. As he spoke, Ethan watched the judge's stoic expression, noting the slight furrow between his brows when the attorney insisted the trooper's split-second decisions were reasonable and entailed qualified immunity. When the county attorney concluded, Ms. Jansen rose to present the plaintiff's response. She spoke succinctly, then turned to Ethan. "Mr. Parker," she said, voice low but clear, "will address the trooper's personal liability." Ethan stood, smoothing his tie. His heart hammered, but his voice was steady. "Your Honor," he began, "this case turns on whether Officer Bradford violated clearly established Fourth Amendment rights by unreasonably extending a traffic stop after correcting a minor equipment violation. The law is unambiguous. Once a stop's purpose ends, any further detention requires independent suspicion of criminal activity. It is beyond dispute that Mr. Reynolds' detention continued without such suspicion." He clicked to his first exhibit, excerpts from Rodriguez v. United States and Rodriguez's Prodigy. He cited Judge Elwood's own summary judgment criteria on disputed facts requiring trial. He highlighted the trooper's deposition admissions. No documented odor, no basis for extending the stop beyond his subjective hunch, and no body camera or dash cam recording of real-time suspicion. The county attorney attempted to interject, but Judge Elwood raised his gavel. Ethan nodded and continued. Moreover, the department's failure to provide clear training on when a traffic stop must end does not shield them from liability. Chief Hayes conceded in deposition that officers receive only generalized legal standards without practical checklists or supervisory oversight. That systemic ambiguity directly contributed to Officer Bradford's discretionary overreach. He turned to deposition transcripts from Chief Hayes's testimony on internal memoranda. Any internal discussions are being withheld under the deliberative process privilege. Yet under EPAV Mink and in RE sealed case, that privilege cannot swallow constitutional rights. We move to compel these communications so the court may assess whether the county's policymaking was constitutionally adequate. Ethan paused to let the weight of those words settle. He felt the courtroom's hush press in around him. Finally, he said, qualified immunity does not apply where a reasonable officer should have known the law. In Pearson v. Callahan, the Supreme Court recognized that an officer who fails to adhere to bright-line rules, such as those governing traffic stop scope, loses immunity. Officer Bradford's reliance on an undocumented odor claim, admitted only under pressure, falls far short of an objectively reasonable standard. He closed his binder. For these reasons, summary judgment is improper. Genuine issues of material fact remain, including the trooper's state of mind and the department's policy failures. We request denial of the motion and that this case proceed to trial. Ethan sat, breath steady. Across the table, Ms. Jansen gave him a discreet nod of approval. The county attorney rose to deliver a brief rebuttal, but Ethan's argument had resonated. He saw Judge Elwood lean forward, eyes fixed on Ms. Jansen as she quietly answered the final question. After closing arguments, the judge signaled recess. Ethan and Ms. Jansen stepped into the hallway. He exhaled, tension easing for the first time in months. They were ready for everything, Ms. Jansen said. You were precise, persuasive, and professional. Ethan offered a tired smile. Thanks, I just spoke the law. She bumped his shoulder lightly. That you did. Now let's wait for the ruling. 2 days later, Ethan sat at his desk at home, surrounded by textbooks and violin sheet music. The email notification chimed. Court issues ruling in Reynolds versus Franklin County. His heart thumped as he clicked the message. He scanned Judge Elwood's words. A detailed analysis reciting the Fourth Amendment standards, the undisputed facts from depositions, and the department's policy admissions. The judge found that genuine disputes of fact precluded summary judgment, and granted the plaintiff's motion to compel internal memoranda. He scheduled a trial date for 6 months hence. Ethan exhaled a laugh that wobbled between relief and triumph. He shared the news with Ms. Jansen, who nearly dropped her coffee in excitement. We did it, Ethan whispered. We really did it. The next day at school, as he crossed the quad, Carla waved enthusiastically. Ruling came down? They said trial, she beamed, handing him a printed news clipping. You make all the headlines. He laughed and slipped into his mock trial meeting, where he coached younger students on handling evidentiary hearings. They peppered him with questions about summary judgment and privilege, and he answered patiently, recalling his experience less than an hour before. That evening, a small celebration took place at the law clinic. Mr. Reynolds arrived with his social worker friend and several members of the local civil rights community. They presented Ethan with a framed certificate of appreciation for his dedication and excellence. He blushed as Mr. Reynolds clasped his hand. Ethan, you restored my faith in justice, Reynolds said, voice thick with emotion. Thank you for believing in me and the law. Ethan responded, Thank you for trusting me, sir. Justice is a team effort. As the applause died down, Ms. Jansen raised a glass of sparkling cider. To Ethan, who showed everyone that age is no barrier to excellence in advocacy. Others echoed the toast. Ethan lifted his glass, his eyes shining. Later that night, Ethan retreated to his bedroom. He placed the certificate on his desk, between a violin trophy and a physics award. He sat at his desk lamp, opening his law school acceptance letters. Final confirmations that his path would continue beyond high school. His phone buzzed. A text from his orchestra conductor, inviting him to perform a solo at the spring concert. Another from Carla. Congratulations, and a reminder of their weekend study session. He looked out his window at the quiet street below, reflecting on the journey from Chapter 1's nervous motion argument to Chapter 8's summary judgment victory. He had grown from a teenage intern into a confident advocate, shouldering real responsibility for real lives. He reached for his violin and played a soft, hopeful melody, each note echoing the promise of new beginnings. The music swelled and softened, filling the room with warmth. In the mirror's reflection, Ethan saw not just a teenager, but a future lawyer, a guardian of rights, an agent of change. He allowed himself a final, contented smile. Justice had prevailed, but more importantly, he had discovered his calling. And as the last note resonated into silence, Ethan Parker, attorney and artist, prepared for whatever awaited beyond the courthouse doors.